if I
All
can.
right. So, good morning, everyone. Thank you so much for joining us today. My name is Liz Locke. I am the Program and Outreach Specialist here at the Wood County Committee on Aging. And we are very excited today to have a presentation with Judge Matt Reger from the Wood County Common Pleas Court. He is giving a presentation today on the Constitution. This is part 1 of 4. Judge Reger will be returning in the next 3 Mondays at 10 a.m. to give some more information to us. We're really excited for this program, and all 4 of these programs will be recorded and will be accessible through our YouTube and our website so that you can reference them later if you happen to miss anything or would like to listen again. So on that note, Judge Reger, I will turn it over to you.
Okay, well, thank you very much, Liz. Actually, I know what Liz said in regard to muting you. I really hope that you do submit questions and you submit comments as we go along. I know that many of you have come to this conversation or this discussion or presentation, if you want, with ideas and questions you have about what the Constitution means within the context of what's happening today. And that's very good. That's relevant for what we're talking about. What I'm going to start out today, though, is kind of give a historical background. Many of you may already have this knowledge, and you may already be aware of this, and you may think that this is a little bit redundant. But I think that it's important to have a very good discussion about the history that underlies the Constitution and how we ended up where we did. But before I do that, and this is kind of, I want you to think about this, and if you want to put this in your text and your submission to Liz, this is the next slide in my presentation. And what the question is, which verb would you use when you are describing the United States of America? Do you say the United States are, or do you say the United States is? Okay, now that's an interesting discussion, but it goes to a central theme of what we have continued to discuss in the United States. I would say to you that there is a definitive point when we went from the United States are to the United States is. And we'll talk about that as we go along, but I want you to think about that. You probably most likely say the United States is, but think about it in the context of the United States are. That's pretty much how we started out. And there is a definitive time when we switched over to United States is, but it's an important aspect of what we're going to discuss as we go through this. Now, here's the overall agenda. I'm going to give you a historical overview today. What are the historical and philosophical foundations of the American political system? How did the framers create the Constitution? How has the Constitution been changed to further ideals in the Declaration of Independence? And how are the values and principles embodied in the Constitution shaped American institutions and practices? What rights does the Bill of Rights protect? And what challenges might face the American constitutional democracy in the 21st century? So those are our goals and ambitions of what I hope to accomplish over the next 4 weeks. But the first thing we've got to start with, and it's hard to find out the start. A lot of people think that maybe 1776 is a good place to start in the Declaration of Independence. But there's something that came before that that really begins this. Some may say, well, when the Pilgrims landed here. I think that's a little too far back. And the one event that really is definitive in starting the American Revolution and what led up to the Declaration of Independence is the French and Indian War, or what's also known as the 7 Years' War. The 7 Years' War, or the French and Indian War, basically at that time you had the French and the English who were trying to compete for land in the American colonies. The French had the area of Canada and west of the Appalachian Mountains, and then the British had east along the Atlantic coast. and they were battling over that. When the war began, the British seemed to have the leading edge on, the French had the leading edge on it. The French were beating the British at an exorbitant rate. The British were losing, and it looked like they were going to lose the entire continent. But William Pitt, who was one of the ministers in the Prime Minister's cabinet at the time, decided that they needed to spend an exorbitant amount of money to win the war. And so he took out large amounts of loans to be able to afford the amount of military might to defeat the French. And ultimately, as you probably already know from American history, the French were defeated in the French and Indian War, and the British took the land of Canada. The Treaty of Paris ended the war, and Canada took over most of the land that was held by the French, included Canada and other places. And actually, I have, and I'm hoping I can show that to you, a video that I want to share with you that kind of outlines the French and Indian War for you. And I think it's a helpful video for understanding this. So I'm going to share that with you, and we'll watch that real quick.
Very beginning, colonialism in America meant competition. European countries were eager to gobble up as much land as possible in the New World. Sometimes this competition turned into open warfare, and the French and Indian War is a perfect example of this. Here's a crash course of 5 things about the war to get you up to speed. North America was a big, beautiful place full of endless...
Is my video showing or not? Okay, just a minute, I'm sorry. Okay, got it.
It is on the screen now.
Okay, that's what I want. Okay, thank you.
European countries were eager to gobble up as much land as possible in the New World. Sometimes this competition turned into open warfare, and the French and Indian War is a perfect example of this. Here's a crash course of 5 things about the war to get you up to speed. North America was a big, beautiful place full of endless opportunities, and Great Britain and France each wanted a piece of the action. The British controlled their 13 colonies and were looking to expand west. The French occupied Canada and were looking to expand south. It was inevitable that they'd bump into each other, and that's exactly what happened in the Ohio River Valley, an important trading area with access to the Mississippi River. The French and Indian War marked the debut of 21-year-old George Washington, a lieutenant colonel for the militia in the British colony of Virginia. In 1754, he was ordered to protect a British fort near what is now Pittsburgh. On the way, Washington encountered a French military unit, and the two sides fought in the first battle of the French and Indian War, the Battle of Jumonville Glen. Washington was young, but he was quickly gaining the experience he would need to eventually command the Continental Army. Years of territorial scuffles turned into full-blown declarations of war in 1756. As fighting broke out, the British and French sought allies among the local Native American populations. The French were familiar with many tribes through trade and recruited the Potawatomi, Winnebago, Ojibwa, Mississauga, and the Huron, while the British turned to the Iroquois Confederacy. At first, the French were winning a lot. They simply had more troops and better supplies than the British Army and drove them back toward the 13 colonies. But the tide turned in 1757 when British Secretary of State William Pitt took control of the war effort. Dreaming of a vast British Empire, he made it his mission to defeat the French in North America, pouring in generous funds to beef up military resources on the ground. The war ended with the French defeat at the Battle of Quebec and the signing of the Treaty of Paris in 1763. The British gained control of Canada and all land east of the Mississippi River. It may seem that the British made out well after all was said and done, but there was a catch. You see, William Pitt borrowed heavily to finance the French and Indian War, which left his nation in tons of debt. To make up for it, the British taxed American colonists up the wazoo. Americans didn't particularly appreciate this. Years of protests, rallies, town hall meetings, and petitions would eventually lead to the American Revolution and the creation of the United States. The French and Indian War may not have had the glorious battles or fearless heroes of other great conflicts, but it was one of the most consequential wars in American history. It also opened the eyes of a young military leader to the tyranny of the British, a man who would go on to be the first American president.
So there we are. And so the French, okay. So there we are. And what we've seen there is that I give at least an idea of the French and Indian War. First of all, the most important thing is it created a large amount of debt, and the British wanted to be able to get that debt paid off. And the way to get that paid off was to tax the colonies. I know that I bring this up every time, and when I talk to or teach this class or talk about this class, is I talk about a situation that I've always I heard about and continue to like to share. It was a student who was in a class who the professor was talking about the American Revolution. And the student raised his hand and said, "Professor, I'd really like to know what was the single cause of the American Revolution? Was it the Townshend Acts? Was it the taxation without representation? Was it the T-tax? Was it the impressing of individuals and their taking of their homes for housing for military? What was the one thing that led to the American Revolution?" And the professor sat and thought, and he said, "You know, it was just one damn thing after another." And really, that's basically what it is. It was one thing after another that happened. There were minor revolts, minor revolutions, and then basically that leads to 1776. Now, I want to give you, this is something you've seen, is that I think you've seen this join or die. And a lot of people think it has to do with the revolution, but it doesn't. This was an advertisement used by Benjamin Franklin, or at least it was a political cartoon that he used in regard to the fight against the French in the French and Indian War. Now, here's what happens, is that in 1776, we have the Declaration of Independence. And at that point, we create a document that says some ideals that we think are important. And those ideals are going to be a part of a conflict that exists throughout our American history. The Declaration of Independence says that all men are created equal and endowed by their Creator with certain inalienable rights. Among those is life, liberty, and the pursuit of happiness. We've all heard it, we all know it, okay? And what that document says is that you have rights that cannot be taken away by the government. And I want you to remember that. I want you to think about that, is that you have these rights that you're born with. Life, liberty, and the pursuit of happiness, which belong to you and you hold on to forever and can never be taken away from you. Now, we're going to talk about why we need government, because once they'd signed the Declaration of Independence and they were starting to fight the war, the government was really encapsulated in the Continental Congress and in the person of George Washington. And that's where I'm going to take a little bit of a rabbit hole here. In that video, they talk about George Washington. George Washington did learn about military campaigns and did rise to some kind of prominence during the French and Indian War. That made him probably the indispensable person of the 18th century. Now, people might contend with this and argue with this, but the point that I'm going to come across, and we can actually discuss this at a later point, is that the most indispensable person of the 18th century in the United States would have to be George Washington. Much of what we have and the way that we are today is partly because of George Washington's leadership as both a general during the Revolutionary War and as our first president. And I think that comes out when you look at the history of the era and the time and what has occurred. Now, so at this point, the Declaration of Independence is announced. We have a form of government under the Continental Congress. The war is won in 1881, and it finishes at that point. So then they come up with a government called the Articles of Confederation. The Articles of Confederation preserve really the primary reason they were fighting was against centralized government. These were people who did not trust centralized government. They believed in local authority. They believed that their states were really the government that they were fighting for. And so at that time, the United States of America there were 13 colonies that were gathered together. They each had their individual constitutions, their individual authority. But what had happened was they had created a federal government that didn't have any kind of power. And which was very upsetting to George Washington was the fact that we created a government that couldn't pay its military. And many of the things that were important within a country to succeed and develop were not able to be accomplished under the Articles of Confederation. I think we all know that the central federal government was just weak. And so there needed to be a government that was strong enough as the central government, but willing to relinquish power to both the individuals and the states. And how do you balance that? In doing that, you need to go back to the ideals of what government's about. Why do we need government? Government, what is the purpose of government? And luckily, about 200 years before the American Revolution, two people had debated this. John Locke and Thomas Hobbes. We're going to start with John Locke. John Locke, understand this, is that John Locke and Thomas Hobbes believed that we started in the state of nature. They believed that individuals begin in a state of nature, but they had different views. Thomas Hobbes believed that people were essentially evil or bad, okay? And they were only interested in their self-interest. John Locke believed that people, although maybe having tendencies towards bad things, could be good and could join together in social institutions to do good things. In the Hobbes thought that people were born free and equal, and they have the right to do what's necessary to survive. Locke says that people are born in the state of nature, but they can work together with reason and common authority. But Locke thought that, here's what happens is Hobbes believed that when you entered into a government, that you relinquished all of your rights. And the only rights you had were those that were given to you by the government. Locke believed that you retained rights. He believed you retained the rights to life and liberty and the possession of property. So he believed firmly that you retained certain rights, and Hobbes did not believe that. And this is a conflict. It's a conflict that exists today still, and it's a conflict that we have within the Constitution. And it's a conflict that actually is, we're going to continue to talk about within the context of what I'm going to call the dichotomy between the Declaration of Independence and the Constitution. And I want to lay that out to you. The Declaration of Independence says that all people are created equal and that they have the right to life, liberty, and the pursuit of happiness. That means that then it says it's an inalienable right, a right that can't be taken away from you. So life and liberty can never be taken away from you according to the Declaration of Independence. When we get to the Constitution, we're going to talk about the Fifth Amendment and the 14th Amendment. We're going to start out with the Fifth Amendment, but when we get to the 14th Amendment, we are going to talk about some things that are pretty radical, I guess, in regard to ideas and thoughts. But the Fifth Amendment says this, that life, liberty, and property may be taken away from you through due process. So it says this, is that life, liberty, and property may only be taken away through due process. So understand that is that the Declaration of Independence says that you have inalienable rights that can never be taken away from you, which are life, liberty, and the pursuit of happiness. But the Constitution says, yeah, life, liberty, and property can be taken away from you, but only with due process. And that creates a conflict between the two. And it's the conflict that existed between Locke and Hobbes. Hobbes believed that when you entered into government, you gave up all of your rights and only had those rights that were given to you by the government. Locke believed that when you entered into, you retained certain rights. And so that's one thing to really remember, and how that conflict exists and how that entered into the ideas of the founding of our government. Remember that Jefferson, along with 4 other individuals, including John Adams, wrote the Declaration of Independence. The ideas, the Lockean ideas of retained rights was something that both Jefferson and Adams believed in. And this is where I'm going to stop for just a moment to explain something. Some of the things we're talking about here are political ideas. I want to tell you that the Constitution of the United States of America is a political document used by people on different sides of the aisle, left, right, whatever, to advocate their ideas that they believe about this country. And that Constitution will be a political document that exists continually. I'm not talking about it as a political document. It is also a legal document. And that's really where I'm going to talk about this as a legal document, and how that Constitution has influenced and developed our legal history in this country. Finally, it is also a cultural document. There are things within the Constitution that we culturally have accepted. And let me give you examples. I think everybody who's sitting here believes in the freedom of speech. They culturally believe in that. We believe in the jury trial system. Once again, it's part of our culture. Think about things that are decided by a vote or by a jury type thing. Even American Idol and things like that are done by what's called by a jury kind of system. So the Constitution is a cultural document, a political document, and a legal document. I'm going to focus a lot on the legal aspect of it. I know that everyone comes here with different political ideologies and backgrounds, and they can see justification for their ideologies in the Constitution. I'm going to hope to avoid that ideology and just talk about the legal development of this. But that doesn't mean you need to withhold that. You can bring those ideas up and we can discuss those, but I'm going to always answer it within the context of a legal document. The next thing we need to talk about, and this is where I may have failed, I guess. At the beginning, I should have introduced myself a little better. My name is Matthew Reger, and I am a common pleas judge here in Wood County. A common pleas judge is a judge who hears basically any kind of case in regard to felonies, criminal matters, civil matters, typically more than $10,000. And we also hear domestic relations or divorce cases. My jurisdiction is the county, is Wood County. I've been here for 4 years as a judge. Prior to that, I spent 20 years as a municipal prosecutor for the city of Bowling Green and the townships that are part of the municipal jurisdiction of the Bowling Green Municipal Court. And then before that, I worked as a staff attorney for a common pleas judge, Judge Charles Kerfus. In between that, I spent a year away in the Republic of Georgia as a criminal law expert. And if you don't know, the country of Georgia lies just south of Russia, next to Armenia, Azerbaijan, and Turkey. I was there with the American Bar Association doing democracy building. I was training attorneys there in our system of justice in regard to the adversarial system. And what I mean about the adversarial system, it's a system where there are two parties presenting conflicting ideas. And by presenting their conflicting ideas is the hope that there will be a truth or a common idea that comes out of that. And I was developing that by training attorneys in the Republic of Georgia. Well, that gets me back to where I was trying to go at. In the Republic of Georgia, they had formerly been part of the Soviet Union. I think everybody here at least can remember the Soviet Union and what that was. The Soviet system was a totalitarian state that had a justice system that really would not be akin to what we would think would be justice. Now, what happened in Georgia was they had a revolution in 2004. They had a revolution and created a completely new government. In doing that, though, they had to do something that we never had to do. They had to create a new justice system. And that's one of the things that we didn't have to do. What we did was we continued the common law system that had existed in England. Let me bring that to kind of a picture for you. I think maybe you have heard in history about 1066. In 1066, the Normans come across the English Channel and they conquer England, developing an entire new monarchy. Well, that monarchy was developed by William the Conqueror. His son inherited the throne. His son was Henry. Well, Henry was not able to really have an heir. He had a lot of different children by a lot of different women, and so he had a lot of different illegitimate children. But he had only one legitimate male heir. And in 1120, that male heir met to a disastrous fate in what's called the White Ship. What had happened is that the male heir to the English throne was being crowned Duke of Normandy, and he had been crowned this. It was a precursor to being crowned King of England. His name was William also. Well, everybody on what's called the White Ship were leaving the French coast in November of 1120. Everybody on the ship was drunk. The ship struck a rock, it sank, and everybody was killed except for one person who was a butcher trying to collect some money for some meat he had delivered. He wrapped himself up in the skin of an animal and made it to shore. That left the heir to the throne of the English monarchy dead, and the only other heir, a female named Matilda. Now it's 1120, and many of the dukes and lords of that time were not willing to accept a female heir to the British throne. But Henry made sure that everyone swore an oath to his daughter Matilda. So all of the barons swore their oath to Matilda, but when Henry died, they reneged on that, and only part of them continued their oath to Matilda. Many of them left and committed themselves to a man named Stephen of Blois. Stephen of Blois was Henry's nephew. Henry's nephew pursued the crown, and this led to an anarchy for about 20 years. During that period of time, there was a battle for the crown, but ultimately Matilda gave up, left for the mainland, and allowed Stephen to take the throne. But Matilda had a son. Her son was named Henry also. When Henry turned 17, he decided, you know, that's my crown, I'm going to take it. So he comes to England, he fights the battles, and ends up getting a draw with Stephen of Blois. They come up with an agreement. Stephen says when he leaves the throne, he'll give it to Henry, and he'll be Henry II. There's an agreement signed, and 30 days later, Stephen conveniently dies. Then Henry becomes Henry II. But Henry knows that he needs to consolidate power. If he doesn't, he's just going to have another anarchy. So he creates what's called the Assize of Clarendon. An assize is a traveling court. It would go around to shire, and at each shire, a group of men from that community would report the crimes that had occurred in that shire in the last year. The assize would then judge each one of those crimes. That is the beginning of what we call the grand jury system. It is also the beginning of what we call the common law system. The common law system is where judges interpret the law, and from that, people can take as how to apply the law. I think we're used to that today when we hear decisions from the Supreme Court. The Supreme Court makes a decision. The decision is typically in the context of what is constitutional or not constitutional. We're going to get to how that began, but the fact of the matter is that is the common law system where judges made the law. Well, within the English common law system, there is no written constitution. The Constitution comes from the decisions of judges and the laws created by Parliament. Well, in 1787, we were going to marry the common law system with a written constitution, a constitution that set out how a government is constructed and how it's supposed to work in Articles 1, 2, and 3. Article 1 being the legislative, Article 1 being the executive, Article 2 being legislative, Article 3 being the judiciary. You understand we have these three branches of government that create our country and allow us to be what we are today. Then, when the Constitution is created, there's also at the same time debate about what rights should be given. Understand, there is still this debate about between Hobbesian and Lockean people of whether or not you have retained rights or rights given by the government. And so we have the first 10 amendments, which grant rights to citizens and gives those rights to them in regard to the construction of the Constitution. So I'm going to skip over this. Okay, so that's where we are in regard to the Constitution and how it's created and how we are where we are. Let me sum up. We lived in an English common law system where judges determined and interpreted law and Parliament created law. Now what that meant is that you had Parliament creating law, but judges were interpreting the law. But there was no ultimate authority, understand that, except for Parliament and the king. Judges could interpret the law, but Parliament could change that law, or the king could change that law. We created a three-part system, trying to include that system of the monarchy through the executive branch, but then we have the legislative branch, which kind of brings in that whole parliamentary system. And then we have a judicial branch, which includes the judiciary as we had envisioned it. So we've married these systems together, and now we have the conflict. Do we have retained rights? Do we have just the rights that are granted through the Constitution? We have a written Constitution, but judges can interpret the law. How do all these things work together? And that's what we're going to get to the next time we meet. But at this point, what I'd like to do is open it up to questions and discussions. And understand, questions and discussions don't have to be just about what we discussed here today. It can be in general to the Constitution. I also understand that we are talking about huge and difficult ideas that you may have gone a little glossy on during this presentation. And I'm willing to discuss that even further, to explain it even further. Or you may have some distinct opinions or ideas about what you've already know about that maybe I've not even thought about. Okay, so let's go on out there. Any kind of discussion?
I have asked everyone to unmute, so you should have an option on your screen to do so if you have any questions you'd like to ask.
Yeah, I have a question.
Sure. I gather they were judges, the first judges after William the Conqueror, and they went around in the circuits. Yeah. And they didn't have a written constitution, so how did they make their decisions? What did they base them on? Basically, they would, that's a very good question. That's an excellent question. They were not deciding constitutionality of laws. What they were looking at is fairness of laws.
Right.
And so what they were doing is, it was more Solomon-esque, is they were deciding disputes between people. They would come to them and say, this is a good point to think about, is that if you were assaulted, so let's say a crime happened against you, you would individually bring a claim against the person who harmed you. But it would be a criminal act that you were asserting. But you would prosecute it, and the other person would respond to it. This led to the idea in the criminal context, a defendant didn't need to have an attorney because all they needed to do was come in and explain themselves. So a judge was really just deciding facts and applying whatever law there was. There was very little law. I mean, back then, theft was pretty much the offense. Murder, you know, the big offenses that we think of today were the big offenses then. There wasn't a lot of other crimes, and crime developed over time. So for example, the idea of burglary. So somebody sneaks into your house and they steal something, or they sneak into your house with the intent of stealing something, but they don't do it. Have they committed a crime? Well, through the common law system, they developed the idea of burglary, saying, yes, they did commit a crime. And then also, now understand, the king would make laws. In the 1100s, in the 12th century, the king was making the laws. There was no parliament. It wasn't until about 1215 with the adoption of the Magna Carta that we began an idea that grew into parliament.
Okay.
I may go on a little bit too much.
Yeah.
I'm sorry, but
No, it's fine.
I love the questions. So other
Okay.
questions?
Does anyone else have any questions?
Judge Reger,
Yeah.
this is Janice's husband. It's interesting how the king was all powerful back then, and now it's kind of switched, you know, with our late 1700s, whereby it seems like, you know, Congress had a lot more authority as far as creating laws.
Well, that's an interesting comment you make. It's interesting. When I took English constitutional law, I love that class. It was a 2-semester class at Michigan State University that I took. The woman who taught it still teaches it today. And she taught it in one of the oldest buildings in the school. And I remember walking upstairs to it, everything creaked. And I think she had dated Henry VIII at one time. That's why she knew so much. But in any event, what she told me was something that still sticks with me today. Even an absolute leader is only leads with the consent of the governed. So I want you to think about it. I'll say that again. Even an absolute leader needs the consent of the governed to lead. Yes, if you want to say that, at the founding of the British Empire, the king had pretty much absolute power, but even that power was subject to restraint and the king's own limited ability. So let's go to what we all have heard about is the Magna Carta. In 1215, a group of lords and barons from throughout England gathered together at what was called Runnymede and forced King John into signing an agreement which gave them certain rights that we still have today in our Constitution. And they were able to force him to do it because he was a weak king. Subsequent kings to King John were stronger, but they continued to enact the Magna Carta as a way of appeasing sometimes. And that led to the creation of Parliament. And Parliament, over time, creeped into the power of the king. And then, as we know, the British Civil War, the English Civil War, which brought the changes there and brought the power to the Parliament. The founding of our country meant, in the founding of our country, intent of the founders that Congress would be the greatest power. That is why they have the purse strings. I would tell you that in the 200 years of our country, I think that there has been a gradual and maybe even sometimes dramatic giving over of power to the executive. Many times under presidents that are beloved today, but there was a great amount of granting of power to the executive. Other questions? I know we're talking about deep subjects here, but they really affect all of us.
All right. Well, if there are no more questions, I
do have one final thing I do want to share with you. I always like sharing this at the end because this is where we are at the beginning of the Constitution. So I'm going to share this with you. It's more tongue-in-cheek than anything, but I think it's a fun way to end for today. You may have seen this before, but well, so I'm going to share it with you. Just a moment. Here we go.
Do you know about the USA? Do you know about the government? Can you tell me about the Constitution? Hey, learn about the USA. In 1787, I'm told our founding fathers did agree to write a list of principles for keeping people free. The USA was just starting out a whole brand new country, and so our people spelled it out, the things that we should be. And they put those principles down on paper and called it the Constitution. And it's been helping us run our country ever since then. The first part of the Constitution is called the Preamble and tells what those founding fathers set out to do. We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. In 1787, I'm told our founding fathers all sat down and wrote a list of principles that's known the world around. The USA was just starting out a whole brand new country, and so our people.
Whoa. Whoa. I don't know what happened there. Okay, well, that didn't work as well as I'd hoped it would. I guess what I want to say, do I have everybody here still?
Yeah.
Okay.
No.
What I like showing that, and I laugh a little about that, okay. So I laugh a little bit about that, but I like showing that. That's how I learned the preamble to the Constitution when I was growing up. That was an important thing to me, but I want to point out some things. I want you to really get this, is that, and this is important, is that we have a Constitution. We have a Constitution that sets up our form of government, but we also have a Constitution that has inspired the entire world and changed the world. We are a different world than we were 250 years ago because of what happened in the United States. There's a lot of things that have happened in the United States during that time, good, bad, and a lot of things that have, where a lot of people have been hurt, but a lot of things, great things have happened. It's an inspiring country to live in and a wonderful place to be. with a lot of great and wonderful ideas. And I'm hoping that over the next 3 weeks, we'll be able to discuss those more and to see the importance of the United States Constitution. So thank you, Liz.
Yes, thank you, Judge Reger, for being here. And as Judge Reger said, he will give the next part of this presentation next Monday, October 12th at 10 a.m. If you are unable to join us live on Zoom, that will be recorded, and you can access that through our website or our YouTube page. So thank you again, Judge Reger, for being here, and we will see you next week.
Okay, thank you very much. Have a good week.
You
Thank
too.
Bye, Doug.